Something just happened at the Supreme Court that no one saw coming. And I mean no one, not the legal analysts, not the political strategists, and most critically, not Donald Trump's own attorneys. Let me be direct with you right now. What we are looking at today is not another procedural loss. This is not another delay tactic being struck down. What the Supreme Court just delivered is the kind of ruling that legal scholars will be citing 20, 30 years from now as the moment everything changed. And here is what makes this different from every other ruling before it. The process by which this happened was almost entirely invisible, hidden, sealed from public view for over a year. I need you to stay with me for the next 20 minutes because the details buried inside this decision are extraordinary. If you are not subscribed to this channel yet, do that right now. Turn on notifications because this story is moving fast and you cannot afford to be catching up. Here's the detail that almost nobody is talking about. Not the ruling itself, not the headlines, not the reaction from Trump's Truth Social account. I want to start somewhere smaller, somewhere most analysts walked right past. At approximately 11:47 in the morning on the day this ruling came down, something happened inside Trump's legal team that tells you everything you need to know about how catastrophic this moment actually was. Two of his attorneys, senior attorneys, people who have been navigating this legal minefield for months, learned about the Supreme Court's decision the same way you and I did, through a breaking news alert on their phones. Let that land for a second. These are not junior staffers. These are licensed officers of the court, paid extraordinary sums of money, whose entire job is to know what is coming before it arrives. And they were blindsided completely because the proceeding that produced this ruling had been running in total secrecy, sealed from public record, sealed from media scrutiny, and apparently sealed from the awareness of Trump's own legal defense team. Now ask yourself this question. How does a case travel all the way through the federal district court, through the appellate court, and arrive at the Supreme Court of the United States, producing a final, binding, unappealable ruling without the subject of that investigation knowing the full scope of what was being built against him? The answer is a legal mechanism so rarely used that most practicing attorneys will go their entire careers without ever encountering it. Sealed grand jury proceedings conducted entirely out of public view. No docket entries, no oral arguments, no press briefings, nothing. And here's what I want you to hold on to as we go deeper into this story. If this investigation ran for over 14 months without anyone knowing it existed, what else might be running right now that we do not know about yet? That question is not rhetorical. By the end of this video, you will understand exactly why it matters. To understand why what just happened is genuinely unprecedented, I need to take you back through 3 moments in American legal history, because context is everything here. And without it, this ruling just looks like another headline. First, 1974, United States versus Nixon. This is the case every constitutional scholar points to when they talk about the limits of presidential power. The Supreme Court unanimously ruled that Richard Nixon had to hand over the White House tapes. It was a devastating blow. It accelerated his resignation. It became the gold standard for judicial accountability over the executive branch. But here is what people forget. Nixon knew it was coming. The case had been argued publicly for months. There were televised hearings. There were press briefings. Nixon's legal team had time to prepare, to strategize, to weigh every possible option, including resignation. The blow was enormous, but it was not a surprise. Second, 2020, Trump versus Vance. The Supreme Court ruled that New York prosecutors could obtain Trump's tax records. Again, a significant legal defeat. Again, Trump had spent years watching that case develop in full public view. His communications team had time to spin the narrative. His attorneys had time to build fallback positions. By the time the ruling came down, the political response was already drafted. Now here is what is different about what just happened. There were no oral arguments listed on any public docket. There were no media advisories issued by the court. There was no period of months during which Trump's team could watch the threat approaching and prepare for impact. The entire legal confrontation, from the original grand jury subpoena, through the district court challenge, through the appellate review, all the way to the Supreme Court's final decision, happened in a sealed environment that the public, the press, and apparently significant portions of Trump's own legal team knew nothing about. This matters enormously, and here is why. Every previous time Trump faced a major legal setback, he deployed the same strategy. He attacked the process publicly. He rallied his base around the narrative of persecution. He used the time between the threat and the ruling to shape how millions of people would interpret the outcome before it even arrived. That strategy requires one essential ingredient: Time and visibility. You cannot fight a war you do not know is being waged against you. The Supreme Court, in conducting these proceedings entirely under seal, effectively removed both of those ingredients simultaneously. Chief Justice John Roberts authored the opinion. The language is direct and notably unsparing. The ruling states that the subpoena targets materials tied to conduct falling wholly outside any credible assertion of presidential immunity. That is not cautious judicial language. That is a door being shut. And now we need to talk about exactly what was behind that door. Here is where we get into the architecture of this ruling. And I need you to pay close attention because this is where the real weight of what just happened becomes impossible to ignore. The Supreme Court's order does not simply demand documents in a general sense. It identifies three distinct categories of materials, three separate areas of potential exposure. And when you lay them side by side and read them together, a picture begins to emerge that goes far beyond anything currently being litigated in any public courtroom in America. Let us go through them one by one. The first category is financial records. Specifically, complete financial records from Trump's business operations going back to 2015, every transaction involving foreign entities, every loan agreement along with its detailed terms and conditions, every internal communication related to property valuations. Now, on the surface, this might sound familiar. We have heard about Trump's finances before. We have heard about the New York fraud case. We have heard about the tax records. But I want you to understand something critical here. Those prior cases dealt with specific transactions in specific jurisdictions. What this subpoena is reaching for is the comprehensive architecture of a decade of financial activity across multiple international relationships simultaneously. Campaign finance experts interviewed in the days following this ruling noted something significant. The scope of what is being requested suggests prosecutors are not filling in gaps in a story they partially know. They appear to be building a complete map of something they have already partially traced from the other end. That is a fundamentally different kind of legal threat. The second category is where this ruling moves into territory that most analysts are genuinely uncomfortable discussing. The subpoena demands all communications between Trump and certain foreign nationals. And here is the detail you need to hold on to. The identities of those foreign nationals are redacted in the public-facing version of the ruling. They are hidden, concealed specifically for national security reasons. I want you to think about what that means for a moment. In American jurisprudence, you do not redact the identity of a foreign business contact because they run a hotel chain or own a real estate portfolio. You redact an identity for national security reasons when the disclosure of that identity could compromise active intelligence operations, reveal the nature of foreign government involvement, or expose relationships that extend into areas the government is not yet prepared to discuss publicly. The language used in this section of the ruling is extraordinarily careful. It refers to communications that go beyond routine business interactions and touch on matters the court describes only as being of significant national concern. Legal scholars analyzing this specific section have noted that this phrasing mirrors the statutory language used in cases involving foreign intelligence surveillance. That is not an accident. Prosecutors do not reach for that language carelessly. The third category is arguably the one with the most immediate political and legal consequences. The subpoena requests documents connected to efforts to obtain anything of value from foreign sources in connection with electoral activities. Read that phrase again slowly. Anything of value from foreign sources in connection with electoral activities. That is the language of campaign finance law. Specifically, it mirrors the statutory prohibition under federal law that makes it a serious criminal offense for any person to solicit, accept, or receive a contribution from a foreign national in connection with a federal election. Campaign finance attorneys watching this ruling noted publicly that prosecutors do not borrow that precise statutory language in a subpoena unless they already have evidence suggesting a potential violation and are seeking documentary confirmation to solidify the case. Do you see what is happening here? Each of these three categories is dangerous on its own. The financial records alone represent years of potential exposure. The foreign communications alone carry national security implications that extend far beyond a standard criminal case. The electoral documents alone touch the very foundation of democratic integrity. But together, Layered on top of each other, they suggest an investigation that is not about any single transaction, any single conversation, or any single decision. They suggest an investigation into a pattern, a sustained, interconnected pattern involving money, foreign relationships, and the machinery of American elections. Now, here is the question that every legal analyst should be asking, but very few are asking loudly enough. If this investigation has been running for over 14 months in total secrecy, and it has already advanced to the point where the Supreme Court is issuing binding compliance orders with a 72-hour deadline, how much does the prosecution already know? How far along is the map they have been drawing in the dark? Because subpoenas at this stage of an investigation are rarely fishing expeditions. They are typically the final step in a process of confirmation. You subpoena documents when you already have testimony, when you already have corroborating evidence, when you already have enough of the picture that you know exactly which missing pieces you are looking for. That possibility, not a certainty, but a genuine and well-supported possibility, is what makes this ruling something categorically different from everything that has come before it. Within hours of this ruling becoming public, the reaction was exactly what you would expect, and also something nobody predicted. Let us start with Trump himself. Within 90 minutes of the ruling dropping, his Truth Social account posted a statement that legal analysts immediately flagged as something far more significant than a political tantrum. He did not simply criticize the decision. He did not simply call it unfair or politically motivated. He went further. He publicly declared that he considered the ruling illegitimate. He attacked Chief Justice John Roberts by name, a justice he himself appointed. And then he said something that former federal prosecutors watching in real time described as a serious legal miscalculation. He stated in writing publicly for the entire world to see that he would not comply with what he called an unconstitutional order. I need you to understand why that statement is so significant from a purely legal standpoint, setting aside the politics entirely, setting aside the rhetoric. When a subject of a court order publicly declares in advance that they will not comply with that order, they have just handed prosecutors something extraordinarily valuable. They have eliminated the need to prove intent. In a contempt proceeding, one of the central questions is whether noncompliance was deliberate or whether it resulted from logistical challenges, good faith disputes over scope, or procedural confusion. Trump's Truth Social post removed that ambiguity entirely. Former federal prosecutor Andrew Weissman, speaking publicly in the hours following the post, noted that the statement essentially functions as a written confession of intent to defy a lawful Supreme Court order. Prosecutors do not need to argue about what was in his mind, he told them. Now let us talk about what was happening inside Trump's legal team at the same moment he was posting on Truth Social. According to sources familiar with the situation, the atmosphere was described as something close to controlled chaos. And the reason for that chaos goes back to the detail I mentioned at the very beginning of this video. At least 2 senior attorneys on Trump's legal team had not been fully briefed on this sealed proceeding. Because of the strict confidentiality restrictions governing the case, information had been compartmentalized even within the defense team itself. These attorneys were now facing a 72-hour compliance deadline for a case they were only just beginning to fully understand. There are reports that these attorneys are now weighing whether they can ethically continue representing a client in circumstances where critical information may have been withheld from them. That is not a minor internal disagreement. Attorney withdrawal at this stage meant with a 72-hour clock running would be operationally catastrophic. Any replacement counsel would need weeks, potentially months, to get up to speed. The deadline does not pause for personnel changes, and here is where I want to give you the counter argument, because I think it is important to engage with this honestly. There are people, serious people, not just partisan defenders, who argue that this entire proceeding represents an unprecedented and dangerous expansion of judicial power over a political figure, that conducting a case of this magnitude in total secrecy without any of the transparency that normally governs Supreme Court proceedings sets a troubling precedent regardless of who the subject is. That the rushed 72-hour compliance window does not allow adequate time for legitimate legal challenges to the subpoena's scope. These are not frivolous concerns. The principle that legal proceedings should be conducted transparently exists for good reasons. It protects defendants. It protects the integrity of the process itself. But here is where that argument runs into a structural problem. Trump's legal team did have the opportunity to challenge this subpoena. They challenged it at the district court level and lost. They challenged it at the appellate level and lost. They challenged it at the Supreme Court level and lost. The secrecy of the proceeding did not prevent them from making their arguments. It prevented them from making those arguments in public, where political pressure and media spin could function as supplementary defense tools. And that distinction between legitimate legal defense and public narrative management is precisely what this ruling appears designed to address. The catch-22 Trump now faces has no clean exit. Every available path carries serious consequences. Compliance means surrendering documents that could open entirely new areas of criminal exposure. Defiance means contempt proceedings with the explicit possibility of pretrial detention. Delay is structurally impossible within 72 hours. It is a trap. And according to legal analysts across the ideological spectrum, it is one built entirely from decisions Trump made over the past 14 months. Let us step back from the immediate drama for a moment, because what is happening here is bigger than one ruling, bigger than one deadline, bigger than one man's legal exposure. And if we only focus on the 72-hour countdown, we miss the thing that actually matters most about this moment. This ruling establishes a precedent that will shape American jurisprudence for decades. For the first time in the history of this country, a sealed grand jury proceeding has traveled the entire length of the federal court system, from district court through appellate review to the Supreme Court itself, produced a final binding ruling against a former president, and done so entirely outside of public view. That has never happened before, not once, not in this form. Think about what that means for every future occupant of the Oval Office. Think about what that means for every future candidate, every future official who believes that controlling the public narrative is the same as controlling their legal exposure. This ruling draws a sharp and unambiguous line between those two things. You can dominate every news cycle. You can shape public perception with extraordinary skill. And a sealed proceeding can still be building its case against you in complete silence the entire time. The national security dimension of this ruling deserves particular attention. And I want to be precise here, because this is an area where speculation can easily outrun the available evidence. What we know is this: the court chose to invoke sealed proceedings specifically. That choice is reserved historically for situations involving classified material, active intelligence operations, or circumstances where public disclosure could cause immediate harm to national security interests. The identities of the foreign nationals named in the subpoena remain redacted. The court's own language describes the subject matter as being of significant national concern. What we do not know, and may not know publicly for some time, is the precise nature of those national security concerns. But the question that follows logically from what we do know is one that I think every American, regardless of political affiliation, should be sitting with right now. What do the relevant government agencies know about the relationships described in this subpoena that the public does not yet know? How long have they known it? And what does it mean that a proceeding touching on those relationships was considered sensitive enough to conduct in complete secrecy at the highest level of the American judicial system? Now, I want to give you the perspective that Trump's supporters will offer, and I want to engage with it seriously. They will argue, and some will argue it in good faith, that a justice system capable of conducting secret proceedings against political figures is a justice system that can be weaponized against anyone, that the same machinery being deployed here could theoretically be turned against any future political opponent of whoever holds power. That concern is legitimate. It is worth taking seriously. It is a reason to demand rigorous oversight of how sealed proceedings are authorized and conducted going forward. But it does not change what the evidence in this specific case appears to show. The subpoena was challenged at every level by experienced attorneys making every available legal argument. It survived every challenge. The court found it legally sound. That process, however imperfect, is the check that exists against abuse. The question this moment leaves us with is not whether Donald Trump is guilty of anything. Courts determine guilt. That is not what we do here. The question is whether the institutions designed to investigate, to challenge, and ultimately to adjudicate these matters are functioning as they were built to function. And right now, based on what we are seeing, the answer appears to be yes. Let me bring this back to where we started. A sealed proceeding ran for 14 months without public knowledge. It survived every legal challenge thrown at it. The Supreme Court of the United States has now issued a final, unappealable ruling demanding compliance within 72 hours. 2 senior attorneys may walk away from the case. And the man at the center of all of it publicly declared in writing that he will not comply. 3 categories of documents: financial records reaching back to 2015, communications with foreign nationals whose identities are hidden for national security reasons, and evidence potentially connecting foreign money to American elections. That is where we are tonight. But here is the question I want to leave you with. the question that I think actually matters more than the 72-hour deadline, more than the contempt proceedings, more than any single document that gets handed over. If this investigation ran in total darkness for over a year, building, advancing, reaching the highest court in the land, what does that tell us about how much we do not know about what is still running right now? That question does not have an answer yet, but it will. And when it does, you will want to have the full context to understand it. This channel exists because some stories require more than a headline. They require someone willing to read the actual ruling, sit with the legal language, and explain what it means for people who have lives to live outside of following court dockets. If that kind of analysis matters to you, subscribe right now. Turn on notifications, because the next 72 hours are going to move fast, and the developments that follow this ruling will reshape everything we think we know about where this is heading. Hit that like button. It tells the algorithm this analysis is worth pushing to people who need it. And drop a comment below. Do you think he complies, or does he defy the court directly? I read every single one. I will see you when this breaks open.